Your Honor, this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
Buckle up, folks. Today's courtroom drama stars Michael Valentine, a repeat player in Thurston County who's as committed to his sovereign citizen beliefs as he is to avoiding legal counsel. He's facing not one, but 2 DUI cases, with a history of failing to appear in court. The stakes: tens of thousands in bail, possible years in jail, and conditions that could lock his every move. Across multiple hearings, you'll see Valentine reject attorneys, challenge jurisdiction, and invoke legal theories that don't hold water in any U.S. court. The result is a clash of courtroom, authority versus personal ideology, and the tension starts right here.
Okay. All right, well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asked that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about 30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any member.
Here's one of the most common sovereign citizen arguments: the so-called right to travel without a driver's license. It's rooted in a distortion of constitutional language. The right to travel means you can move freely between states, not that you can operate a motor vehicle without a license. Driving is a regulated privilege, not an unrestricted right, and every court from state to federal has upheld that. By bringing this up, Valentine isn't strengthening his defense. He's signaling to the judge that he's not working within recognized law, which can drastically hurt his credibility before the bench.
Mr. Valentine, I'm going to hold you on 15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm a seri juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona that I...
This bond decision is textbook risk management. Judges look at two main factors when setting bail: likelihood of appearing in court and danger to the public. With multiple DUI allegations, a history of failing to appear, and clear signs that Valentine doesn't respect court orders, the judge sees both risks as high. Add in alcohol-related conditions and the SCRAM device, and you've got a set of restrictions designed to keep both the defendant in check and the community safe. Valentine might view this as overreach, but from a public safety perspective, it's exactly what most judges would do.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the facts, ma'am.
You can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, anytime you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
One attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do postpone, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm a sound mind.
I'm not denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel and talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. I'm doing that. All right, so we're done today, and those orders will be given to you in the jail.
This is where semantics collide with reality. Sovereign citizens often claim they're not persons under the law, thinking it removes the court's authority. In truth, this argument could strip them of legal protections entirely. The Constitution, statutes, and case law protect individuals, which legally includes persons. If you reject that status, you're essentially arguing you don't have rights under the very system you're fighting. The irony, courts will still treat you as a person because otherwise they couldn't charge or protect you. It's a strategy that backfires before it even leaves the runway.
You can't selectively consent to parts of the court's authority. Saying you don't consent to being held in jail doesn't make a difference because your consent isn't required. Court orders don't operate on personal approval, and with that, we move on to his next hearing where things take a dramatic turn. This time, his entire family shows up in court, setting the stage for an even more intense exchange. Let's take a look.
And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah, hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have advised.
Okay,
I'll
take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
Here's a moment worth noting. The judge isn't flexing authority here. He's actually trying to protect Valentine from himself. Judges know that criminal defense is a complex skill set, not a hobby you pick up on weekends. The legal saying, "A lawyer who represents himself has a fool for a client," exists for a reason. Evidence rules, cross-examination, plea negotiations, these are all things that take years to master. By rejecting legal help, Valentine isn't just taking a gamble. He's stacking the deck against himself before the trial even begins.
That I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
No,
People are
just
special appearance.
no. We're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you. It was why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those.
And here's a contradiction big enough to drive a police cruiser through. Valentine has spent most of his hearing denying he's a legal person, yet now invokes "we the people," a term rooted in collective legal identity. In constitutional law, "we the people" refers to the political body bound by the Constitution, which means persons subject to its laws. You can't simultaneously reject that identity and use it as a shield. To the court, it's more evidence that Valentine's arguments are inconsistent and, therefore, unreliable.
All right, folks, I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to.
I object to that. You're not allowing me.
We'll note your objection. Thank you.
We need to get you unmuted.
Yes, ma'am.
All right, so there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay, I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony, to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay.
Your
Well, this
Honor,
is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
it's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to